Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Today I'm talking about the Chloe Driver trial in Georgia, and it is at once both a fascinating and saddening case. It involves the death of an 18-month-old child. And if this kind of thing upsets you, it's probably not the video you want to watch. There's not going to be any graphic information in here, anything like that. But the overall tenor of this is a fairly sad case. So today I want to talk a little bit about case themes. Now, on the plaintiff's side, we use themes all the time to essentially put a box out for the jury to fit the evidence into. So, for example, in a medical negligence case where a doctor in a hospital misses important clues to what's going on with a patient and that sort of thing, we might use an allegory like he was asleep at the switch, because a lot of medical malpractice happens during the evening hours when doctors are traditionally home and want to spend time with their own families, and unfortunately their duties do call them away. And a lot of times, well, I shouldn't say a lot of times, I would say many times in a medical malpractice situation, the doctor is choosing his own family over the patient, and sometimes that works out very badly for the patient. Like I said, that's not something that happens routinely, but it does happen from time to time. Or we might bring a series of red flags, little red pennant flags, to the courtroom and talk about this red flag waving and another red flag waving. And maybe we would put something like arterial blood gases on one, and increased respiratory rate on another, and increased heart rate on another. And every time during our opening statement that we mentioned that issue, we would raise that little red flag and wave it. And you do that so that you, like I said, you can sort of build a box that you can put the evidence in so that it makes sense. Now, that happens on the plaintiff's side all the time. It also happens in criminal defense. Think about OJ's trial. If it doesn't fit, you must acquit. It was a great theme for a situation where the evidence did not fit the crime that they said it was part of. And then in the Casey Anthony case, you may remember, essentially their theme was, hey, we admit she's a liar, but she's not a murderer. And that theme worked out pretty well for them. In the battle, the state always goes first. And in this Chloe Driver trial, they get to start the ball rolling. And here they are at the beginning, theming their case.
This is Hannah Nicole Driver. On December 8th of 2020, she was 13 months old. This is not the way that you will see her in this trial. Instead, you will see her the way that first responding officers saw her, the way that the EMTs saw her, the way that the ER doctors saw her, and eventually the way that the medical examiner saw her. You will see this 13-month-old beautiful baby girl who had been brutally murdered by her mother, stabbed repeatedly until every bit of life drained out of her, and she died. But I wanted to start with a picture of what Hannah Nicole Driver was like before that happened. You are going to hear that Chloe Driver was her mother, and Chloe Driver was involved in an alternative lifestyle. You're going to hear, as the week goes on, a lot of distracting evidence. You are going to hear a lot of messy evidence about this group, about their belief systems. You are going to hear a lot of things that take the focus off of Hannah Nicole Driver.
Now, I think that's a pretty savvy way for them to start out, because they're drawing attention to the little girl who was murdered in this case, and They're saying, look, you're going to hear a lot of other evidence, but don't forget about little Hannah. It's effective because you show that picture at the beginning and you wind up showing that picture again, and people will remember that sweet little child's photo, and they'll think about that, and I suspect the jury will heed that instruction to keep her in mind. The prosecution here knows that there's going to be a lot of stuff thrown at them by the defense, so they give a little preview.
Now, the state has the burden of proving that she murdered Hannah and that she intended Hannah's death. And that will be very, very clear from the evidence. The defense is raising the issue of insanity and going to ask you to find her not guilty by reason of insanity. And that is their burden to prove. There is a legal definition of what insanity is, and opening statements are not necessarily the appropriate time for us to get into what the law is and how you apply the law. That will be something that comes at the end of this trial.
But it won't come at the end of this video. Here is the Georgia statute that is directly on point here. And here's what it says. A person shall not be found guilty of a crime if at the time of the act, omission, or negligence constituting the crime, the person did not have the mental capacity to distinguish between right and wrong in relation to such act, omission, or negligence. So the key issue is whether the defendant at the time of the crime knew the difference between right and wrong. They could appreciate that difference. So Georgia law presumes sanity, and because of that, insanity is an affirmative defense. Now, the state has to prove sanity essentially by beyond a reasonable doubt, but the presumption of sanity is such that it can be overcome by a mere preponderance showing, simply more likely than not likely. That establishes the insanity defense on behalf of the defendant. So there's no constitutional problem with that. Here's the other thing that's interesting about Georgia law. In Georgia, general insanity is not a defense to the crime. So somebody can be adjudged completely mentally insane, escape from an insane asylum, commit a crime, and they can lose on the issue of an insanity defense because they may have appreciated at the time the difference between right and wrong. In other words, it's not just general insanity being what I would call guano crazy. It is, the difference is that it can be only about the inability to perceive the difference between right and wrong. And there's some really interesting case law out there in Georgia. They say that insanity may, and very frequently is, only a temporary malady. And if the accused at the time of the commission of the crime did not have reason to be able to distinguish between right and wrong, well, then you can't convict him. Here's the other kind of loopy thing about Georgia law. A lay witness may testify regarding a witness's opinion or belief as to the defendant's sanity, giving reasons therefor. However, if the judge excludes that testimony, in most cases, that won't warrant a new trial if there is evidence that shows there was not a question of whether they knew the difference between right and wrong. In other words, Jim Bob can get up and testify that Becky Sue over here was nutty as a fruitcake, but again, if she could appreciate the difference between right and wrong, that testimony and the exclusion of that testimony isn't going to be error. So now you know the law as it pertains to the insanity defense in Georgia.
And so in that regard, the things that I can appropriately tell you is you're going to hear a lot of things in this case about throwing witnesses and evidence, throwing around terms like crazy, mentally ill, insane. And you, as human beings that know the English language, probably use all of those terms kind of interchangeably. But the truth is the law has definitions for things, and they are not the same. So what I would like for you to pay attention to in the presentation of evidence in this case is the evidence that she understood the wrongfulness of her actions, that she understood the difference between wrong and right. And there will be plenty of evidence presented to you that she did. One of those pieces of evidence is When she was sitting in the hospital bed, one of the first things that she wrote to law enforcement, because she could not speak because she had a trach, was, "How long will my prison sentence be for killing her?"
So she inflicted some wounds on herself, ostensibly because she wanted to not be around anymore. And as a result of that, she was in the hospital. And so the police went to interview her, and there is no problem with that. She's not in custody when she's in the hospital. They don't even have to Mirandize her. And so the first question she writes is this thing about, well, how long am I going to go to prison for? Well, again, that does show something of a mental state that suggests you knew you did something wrong. And Georgia law does say that the condition of mind both before and after the event are relevant on the issue of whether you could perceive right from wrong. Her having written out that question has made her lawyer's job incredibly more difficult, and I suspect it's probably going to be one of the things that winds up getting a conviction. But let's go on. So the prosecutor is setting up what the defense is going to show about how crazy this bunch of lunatics that she was out with in terms of their belief system is. And she's going to do it in a rather disarming way, which I think is really important here because a lot of people have different views on religion. And while this touches on religion, I just really think it's more cult behavior. The idea of a cult is that you take people who are weak-minded and you make them follow your dogma instead of what they know to be right. And there is some possibility that, they may have overcome her mental defense mechanisms. But listen to what the prosecutor says about that.
But just in the English language context, there's going to be evidence that comes before you that sounds insane. There is going to be evidence that she believed things that the rest of the group believed too. That the world is fake, that we're living in hell, that they have the ability to, with their minds, control the actions of other people around them. These things were not unique to Chloe Driver. The entire group believed that this higher level of consciousness was something that they were called upon to do, to serve the world. And so what I ask you to do when you are assessing these things is, there may be a question about whether these are delusions or whether these are just genuinely held religious views that maybe are untraditional that the rest of the world doesn't agree with. And that's something that you're going to have to parse out. But here's the thing that is very, very clear and will be very important to your determination in this case. None of these bizarre views had anything to do with Hannah.
Now we move to the defense's opening statement, and essentially they're going to make a play for this insanity defense from the get-go. So if you happen to look at the difference, we have two females arguing against one another here, and I think in terms of establishing some kind of rapport with the jury, the prosecutor has a lot better rapport with the jury than will this second lawyer, simply because she doesn't look like she has everything more or less put together. That's my analysis. I'd love to hear yours, because maybe she's the best lawyer I've ever seen or you've ever seen, but I don't like the way she approached this. So let's take a look at a part of her opening statement and then we'll go on.
There is no dispute as to the facts regarding the events that occurred on December 8th of 2020 at 215 Mountain Vista Boulevard here in Canton. Ms. Driver does not dispute that she killed her 13-month-old baby daughter, Hannah Nicole Driver. There is also no dispute that at the same time, Ms. Driver stabbed herself repeatedly in the neck, not once, not twice, not 3 times, 4 times, and then took the knife to her chest. There is no doubt that the evidence in this case and the testimony you're going to hear by the state of the defendant will not only be difficult to see and hear, but as we go through this trial, the only issue in this case that you need to decide is Ms. Driver's mental status and mental state at the time of the crime. Solely focus
as we sit here and present all of this evidence about what happened that day, and the state does that, on her mental health. We are not standing here saying that Hannah Nicole Driver is not a victim. That is not the position taken by anybody in this case. Our job is to simply show you how we got here today, and that the law allows you to consider her mental state at the time of the crime.
So if you've been paying attention there, she's saying several times now about at the time of the crime. In other words, they are differentiating how she might have felt right before it happened and how she might have felt after it happened. And because at the time of the crime, well, she was just bonkers. So we'll see where this goes, but there are other parts of this where I think she does a little bit better job of kind of laying out her rationale for why this should be the insanity defense. Let's listen.
Several people who claim to love Chloe and care about her are the same people who refused to get her the help she desperately needed and asked for. Benjamin, his other wives, Jason Spillers, Chloe's own parents. They either all chose not to help her and ignored her cries for help, or they just could not break through to her in those fateful months and get her that help she so desperately needed that she asked for.
Now, this seems to me to be a pretty clear attempt to deflect blame onto other people. You know, her husband and the other wife should have known that she was, having mental issues. Her parents should have interceded, even though she's legally an adult, and they didn't even probably know where she was at the time of this. They should have interceded. But nowhere does the burden fall on Chloe. Chloe is just adrift, this innocent young thing that has had her consciousness overwhelmed by another person. And I don't think that particular theme is going to play out well. Now, throughout the course of the case, there's been some really interesting testimony, and we'll get to that in the next video. But this is one of those things where I think if this is your opening statement, you have a really, really long way to go on the defense side to get a verdict that's favorable to you. The jury does have the ability to impose two different verdicts. They can say not guilty by reason of insanity, or they can say guilty but insane. Only if you're found to be guilty but insane are you going to suffer a penalty. You basically go to a mental institution until you are found to be sane again, and then you go and serve a sentence for some period of years. If you are not guilty by reason of insanity, you don't have to go to prison, but you may wind up they may wind up imposing civil commitment on you to get treatment for your mental illness. And civil commitment is a much different standard. So I would really like to know from you whether or not you thought these opening statements were particularly useful. I didn't think the defense opening was very good. I thought the prosecution's opening was very good. And I always have to be alert for bias because I took care of a lot of babies and a lot of infants, and I dealt with a lot of pediatric trauma when I was a respiratory therapist. And of all of the cases that I saw, many of the people who engaged in causing that trauma didn't wind up paying the price they should have. So I am potentially a little bit biased. I feel like it's important to point that out and let you judge my comments from that basis. So if you have the opportunity today to do something kind for someone else, and then if you would, drop a comment down below. You can always email me at the address above. If you haven't subscribed, feel free to. And then come on back down here, join me at the beach, and we'll talk about something else good tomorrow. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.